to continue our theme of things you don't see very often in court, this is the attorneys for a couple that got divorced a few months ago. The husband has filed a motion to have the divorce order reversed. Wait till you hear why.
All right. Well, this is a pretty interesting situation that we found ourselves in here. So we have currently what it shows is we're on for 3 different show cause contempts, but I know that there was a motion regarding the default that was supposed to be passed along, so we could line up everything. Both parties responded to that. I'm assuming we're all comfortable knowing that. Okay, because on the docket it shows the contempts. So
and I saw that as well. So my understanding is we're on for Mr. Hunter's motion to vacate and then our motion for contempt, and that's it. Is that your understanding?
That is my understanding.
That's my understanding as well.
Okay, great.
Okay. All right. I'm going to start with you. Obviously, I think the default issue probably takes precedence in my opinion. So let's start there. So I'll defer to you, Mr. Hunter.
Thank you, Your Honor. I'll keep the points kind of minimal here. I think everything that we filed it contains the bulk of our argument. So just to make some one clarification, Mr. Cutler's grievance with the state bar was filed on February 28th, not the 8th, and that can be shown in our letter from the state bar. That's Exhibit 5 to our motion to vacate. It states that the grievance was filed on the 28th. I think Ms. Roush got the 8th from my memo, which was a typo.
The 8th of February, so same month, just different day. Okay.
Same month, just different days, right? So I just want to make that clarification. And just as a reminder, the rule here that we're arguing for is CR 60B11 and the case law of Barr v. McGugan. I think that's how that's said. And the rule here is that an attorney's actions cannot be attributed to a client when the attorney-client relationship is disintegrated to the point of no practical representation. And specifically in Barr, one of the controlling factors is that the attorney had suffered from a mental illness that had a major impact on their ability to represent the client, as well as a breakdown in communications, even though the client was diligently following up. And here, Mr. Cutler was completely unaware of Mr. South's mental illness. I apologize, I don't know if there's any other attorneys on there. His attorney's mental illness was not known to him until his previous attorney filed a response to his grievance. That was the first he had learned about it, and that was the first time we had realized there was some actionable claim to set aside the final order. Petitioner even acknowledges that Mr. South was completely unaware of the status of the proceedings. Petitioner acknowledges that Mr. Cutler's previous attorney showed up to a trial thinking it was a hearing on a default. And that's also what Mr. Cutler claims as well. He was completely unaware about what was going on in the status of his case, despite reaching out, getting feedback from his previous attorney, and basically getting the wrong information. So he was diligent. He was completely unaware of what was going on, and it negatively affected him. So, and briefly in response to petitioner's memorandum, they rely on the case law of Stanley v. Cole to show that Barr was not a controlling factor in a case where Stanley the attorney did not show up for an arbitration hearing. I really want to point out in the Stanley case, the court in that case specifically noted the number one reason they did not follow Barr was because Stanley did not plead for relief under CR 60B11. That's sort of the catch-all CR 60. They specifically said that's one of the number one reason we're not following Barr. And because Stanley presented no evidence that the attorney had suffered any kind of mental illness. And finally, with regards to the Cutler case having not been heard on the merits, or it being heard on the merits, I think petitioner is trying to state that a one-sided trial is a trial on the merits. The same court that issued the Bard decision issued a decision in re the marriage of laymen. And that's number 33868-1 Roman numeral 3. That was decided in 2017. In that case, the court stated that under Barr, they do express their desire that cases should be decided on their merits. And in a footnote to that sentence, the court goes on to say that we desire, and this is quote, we desire cases to be decided on their merits so that a finder of fact can declare what is true and the law can produce a just result. When an attorney substantially fails to present his or her client's facts to the finder of fact, truth is in doubt, and so is the result. So essentially, just to make it brief, Your Honor, we think Mr. Cutler's position falls squarely within the Barr decision and should be upheld the same. The motion should be vacated and a trial should be held. Thank you.
Thank you, Mr. Walker. Ms. Rush.
Oh, Mr. Hunter. Sorry, I don't want to. Mr. Hunter, there's two Brians at our firm.
Oh, did I say Walker? Mr. Hunter, I apologize. Thank you.
Yeah.
Ms. Rush.
Thank you, Your Honor. So obviously we disagree. And I know you've read the materials, but I'll just kind of briefly go over them. And I know Your Honor's familiar with this case, having heard some of the motions. What we're operating under here, just as a reminder to the court, is there was not only a motion in default that was granted, there was also a motion in limine that was granted that basically said Mr. Cutler was precluded from presenting any evidence or testimony at trial. So those were granted, I believe, in January of 2023, right before trial. And subsequent to that hearing, the next day, Mr. South appeared at readiness for trial. So that's one really important distinguishing factor from Barr is that in Barr, the attorney had completely kind of disappeared, was not participating, didn't have anything to do with the case. In our case, Mr. South appeared at readiness. He appeared at the trial. He indicated on the record multiple things about the case. If you look at the clerk's notes, clerk's minutes. So that's very distinguishable from Barr. In addition, in Barr, there was no trial heard on any sort of merits. Mr. Cutler's position is that because his side was not allowed to present any evidence that there was no trial on the merits here is inaccurate. My client, to be fair and to cover all of her bases, presented testimony. She presented witness testimony by an appraiser. She presented appraisals. She presented multiple financial documents under ER 904, which were then subsequently admitted at trial. So this was not a case where we just showed up and the court said, default granted, you get what you want. My client, out of abundance of caution for this very reason, put on a prima facie case to establish value specifically and to tell the court what her preferred allocation of assets would be. In addition, in Barr, there was a proven record of long-term depression that impaired the attorney's ability to practice law. What we have here is we have one statement from Mr. South, apparently in response to a Barr complaint. And I will note that my office reached out to Mr. Hunter asking for the complaint that his client made because I would like to see the whole correspondence. We didn't get that. So what I have from Mr. South to the Barr, and this is, and with all due respect to Mr. South, this is an attorney who's trying to protect his bar license, is my mother passed away, I suffer from depression, et cetera, et cetera. That didn't inhibit his ability to practice on this case for the 3 years leading up to trial. So unlike Barr, we don't have this long-term, where long-term impairment. We might have had a situational impairment, and that's why the trial got set over in September. That's why he could have asked for a set over in January. And that leads me to my next point, which is my client is not the one who should suffer here because of this. My client is not the one who should face a hardship because of Mr. Cutler's position. Basically, Mr. Cutler's recourse is against his attorney. And that's very solid. The motion to vacate, one of the things that is very clearly stated in the Barr case is that the court cannot vacate if it's going to cause a substantial hardship on the non-moving party. This would cause a substantial hardship on my client, who's already expended tens of thousands of dollars in attorney fees. She's already been declared single by the courts. There are taxation issues. There's a whole host of issues going from divorced to back to being married could have. It would cause her to incur additional attorney fees. which she's had to do to defend against this exact motion. So in looking at just a couple other points that I'll point out for the court, you know, the other remedies that were available to Mr. Cutler is he could have appealed the final orders. They took no action on this for 6 months after final orders were entered. They could have sought reconsideration or something of that sort at the time. The time that lapsed doesn't make sense to me or my client. If they knew that they had an alleged issue about Mr. South, we don't understand why it took over 6 months from when final orders were entered to do something about it. Less than a week before filing this motion to vacate, Mr. Cutler had been in correspondence with various people recognizing the validity of the decree and offering solutions on how to adhere to it. So less than a week before filing a motion asking that this court to set aside the decree, he was recognizing that the decree was valid and was trying to make payment arrangements. So I think, you know, the case law is pretty clear that relief is to be granted sparingly. That's very clear in the case law. He filed for relief under CR 60B11, which is the catch-all provision. There's no request for relief under any other section in that rule. And I think that is pretty clear as well. Finally, you know, in this situation specifically, Mr. South's actions are attributable to Mr. Cutler. Mr. Cutler would have you believe that he was a diligent client, but that he had no idea what was going on with his case. That's just not accurate. This really, you know, there was this singular issue where he missed a hearing. Mr. South missed a hearing on the default and the motion in limine. But then the next day appeared for readiness, appeared for trial. So we don't have the situation like in Barr where the attorney basically disappeared. And I think that's an actual quote from the case. We just don't have that here. And so basically what should happen is the decree should stand. Mr. Cutler has recourse against his former attorney. My client's not bringing this defense forward to be insensitive, but my client put forward an appropriate case. As we put in the record, she didn't take a default and try and run away with it. She really tried to put on what she thought was an appropriate division of the assets, and my client just wants the divorce to stand. I'm happy to answer any other questions that Your Honor has about this. I'm just looking at my notes to make sure I covered everything, but I think that's it for now.
If I may respond, Your Honor.
Yes, go ahead. Thank you.
Just a few quick points. I'll just reiterate that Mr. Cutler's previous attorney did indicate that for 3 years he'd been caring for his mother and had been suffering with clinical depression for years. As for the appeal or reconsideration, I understand Ms. Rush's point. I actually would concede that moving with a default motion in limine in the trial is the appropriate activities to go on. In fact, the reason for the lapse in bringing a motion to vacate is largely because the general rule is a client is held to the actions of their attorney, even if it's negligent or wrong. It wasn't until Mr. Cutler learned that his previous attorney suffered from severe mental illness. It suffered from depression. This put it squarely within case law that opens up for a CR 60B11 motion to vacate. So the 6-month delay, that's the reason. He found out, and it was late August by the time he had learned of this depression. And this has never been disclosed by Mr. South before. This is in Mr. Cutler's declaration. That's the reason here. And we would agree that I think an appeal or reconsideration would be inappropriate because I believe Mr. Rauch followed the steps appropriately. I didn't really see any problems with moving for a default or motion in limine in a trial. But what we're saying here, the basis for this motion is simply because of the mental illness, because of the lack of communication. There is a reason that Mr. Cutler essentially was completely unrepresented when he thought he was being represented. Thank you.
I do have a couple questions. So do you have, and it sounds like Ms. Rush requested this of you, Mr. Hunter. Do you have the initial complaint that was filed by your client to the bar?
No, Your Honor, I do not have that. I have Mr. Cutler is here with me as well. If you'd like, I can confer with him on it. No, I do not have that complaint.
Is that something that he has a copy of that he could provide to all the parties?
We could do that, yes.
Okay. Second thing, and this is just I'm going to throw out a hypothetical. If is this a scenario where if the court were to grant respondents' request on the default, could it be bifurcated in a way that leaves the parties' marriage dissolved, but brings back into so essentially it doesn't we leave the dissolution in place and just readdress the property issues, because that's frankly the money and property seems to be where the concern is. And I know that you may not be able to answer that question. It may be an absurd question. But in listening to Ms. Rush, there's clearly, I mean, 6 or 7 months have gone by since the default was entered. And I cannot imagine what the implications would be for, frankly, either party to be acting, and the tax implications, all the things, to go back and say, okay, wait, nope, we're actually still married for the last 6 months. So I don't know if that's something that could be parsed out. I'm just throwing that out there.
Thank you, Your Honor. I had that same thought fairly recently too. I think we could all agree, and Mr. Cutler doesn't want Ms. Weiss to go back to being married. It's not clear to me if we were to change the final order. One thought I had kicked around is if the order was changed to say reserved on property, for instance. But I think what that does is creates a modification of a final order, and that's not properly before the courts. So, unless Ms. Rush was willing to stipulate to it, I think it's I'm not aware of any legal standard for piecemealing the undoing of a final order. I'd defer if Ms. Rush has any idea.
And I don't believe you can, because if you vacate the order, you vacate the order. And that's the entire order that says the parties are divorced. Here's the property division. So I don't believe you can.
Okay. Thank you. And that was before taking the bench, my primary area of practice was not family law. So I've learned a lot in the last 5 years, but that this is kind of a new situation. I do very much appreciate the memorandum, Ms. Rush, with the case law. Initially, my thought was
Your Honor, I may have one more point my client just reminded me of. I apologize for the mention.
sure.
There, another option, perhaps, item 20 of the final order. This came up in the contempt motion. Mr. Cutler's attempted to refinance his properties. Item 20 has been a concern. And the reason for that is because he has a very particular program that he can go through to refinance. These are FHA loans for his Dusty Drive property, I believe is the one, because it has a mobile home on it. So FHA is the reason he has to go that vehicle. Conventional lenders don't like to deal with mobile homes. So the reason I bring it up, in the alternative, if the order cannot be vacated, the parties may be better suited if item 20 could be changed to allow for payments towards the judgment, because FHA will allow judgments on a decree if it's allowed to be made in payments. But if there's a one-time judgment, like a one-time payment that could create a lien, they don't want to touch it. So it's not a great solution. However, it might be a better vehicle. So I just throw that out there for Your Honor.
I don't know. I'm assuming, Mr. Rush, that might be the first time you're hearing of that.
Yeah, I mean, if they certainly, we've had some correspondence, my office and another attorney's office, about enforcing the judgments. I mean, if they want to make an offer about how to do that, that's one thing. But I mean, I think that removing my client from liability and getting her paid what she's owed under the decree is we could go there, but I mean, I think that's separate from what we're discussing right now. I appreciate that Mr. Hunter's trying to be creative, but I just don't think that falls, I don't know that number one, I mean, I don't think the court has the authority to order that, but certainly if, depending on the court's ruling today, or if the court's going to take it under advisement or what have you, if they want to make us an offer, we certainly will review it, because my client certainly doesn't want to continue to litigate. She'd certainly like to be done with this, but she also feels that she, obviously she has judgments that she's entitled to receive. So.
And I would just state that's what I propose does not change the judgment, the money judgment as it is. It would just allow for payments, which under FHA lending rules is permissible. So it's not, the judgment would still be there. It would just give Mr. Cutler an ability to refinance where there currently isn't one. So, and that's assuming if the court chooses not to vacate the order. So just to clear that up.
Okay. Because these contempts are attached to this issue, and I am going to let the parties know that this is, I am going to take this under advisement, but I do anticipate being able to have a relatively quick turnaround. I don't know if you want to make your arguments on the contempts now, or if you want to wait for a ruling from the court to address the contempts if needed.
Well, Your Honor, I mean, I think the contempt issue is fairly clear. I would defer to Your Honor on that. If you want to make a ruling just based on the pleadings, I'm fine with that on the contempt, because like I said, I think it's, about kind of 5% of what we're dealing with here today. So, and they do go hand in hand.
Anything, Mr. Hunter?
I would agree. And if we're going there, I would just make a few quick points on the contempt. Petitioner agrees. Mr. Cutler is trying to fulfill the judgment. He's trying to, balance his other responsibilities to family, and he offered to make payments to petitioner, which we haven't received any response on. So, in terms of contempt being a, willful violation of a court order, he's trying to comply. He's running into various obstacles, but he's attempting, and we just hope the court takes that into consideration. Thank you.
Okay. And Your Honor, I would just comment, if we're commenting, that he didn't provide any proof really of what his attempts are. Normally in a situation like this, you'd see a letter from a lender, you'd see the letter from the bank. I realize he filed that profit and loss statement, but we provided a breakdown of how that actually shows he's ahead of prior years. So, like I said, he may say, I've been making efforts and I have these family issues. Well, that's not relevant to contempt. I mean, you have a court order to meet a deadline, you didn't do it. That's just a fact. And so, while my client, again, is not trying to be insensitive here, it's very clear cut to us. So, she could have, quite frankly, after the 90 days were up, she could have marched into court with a motion saying, I want to force these properties to be sold. She didn't. She gave him a significant amount of time, more than he had under the judgment. So I think that that's relevant too, just to show that she's really trying to work here in good faith, and that, like I said, we didn't receive anything for like 6 months knowing what was going on. So I appreciate he says he's trying. We just haven't seen the proof of that in the record.
Okay. Here's what I'm going to do. I'm going to set this for the 12th. So 2 weeks from today. My aim is going to be to email a ruling prior to that to the parties. And it may, depending on my time, I don't know what my schedule next week looks like. That either be an email just kind of outlining what I'm going to do, or it could be a formal ruling that I'll file with the clerk, and I'll obviously let the parties know what that is. My hope is that you'll have that at least a few days in advance before the hearing on the 12th. That'll obviously have the ball rolling one direction or the other as far as the contempts. And obviously, if there's negotiations between now and then, that if parties are free to continue any discussions. I would ask, though, that Mr. Hunter have Mr. Cutler provide a copy of the initial bar complaint to Ms. Rush and to the court.
And any subsequent, if there's been subsequent communication with the bar, if we could get that as well. All I've seen is the one letter from the bar to Mr. South and then Mr. South's response back.
Okay.
Subsequent communication from Mr. Cutler, is that what you mean?
Just any communication on the bar grievance, I think would be helpful.
Sure. And I don't know if you can do that, Mr. Hunter, or have your client get that to you and you get that to us by the end of this week. That would be very helpful.
I think we can do that. Would you like me to submit that to your JA, Your Honor? Or-
Sure, that's fine.
Okay.
And then if we need a copy to be filed, we can worry about that later. But
Okay.
I want Ms. Rush to have it. I'd like to be able to review it as part of my ruling as well.
Understood. We can do that, Your Honor.
Okay.
All right.
All right. Thank you all very much. We'll see you in 2 weeks.
Thank you.
Your Honor. Thank you, Counselor.